information in the chat. So welcome each one of you to our roundtable today. Our spotlight speaker is Doug Rowe. He's a partner with Certilman Balin. He's a good friend of mine, trusted advisor, and he's an expert in labor and law. Doug, I have your profile up here. I mean, it's pretty extensive. I mean, most of the folks know you and your background and your company's track record. You know, one of the largest law firms here on Long Island. So we're interested to hear more about your topic for today. And I don't believe a slideshow or anything, Doug. So I'm just going to minimize the screen here so you can kick it off. But thank you for taking the time to speak and share your insights with our group here today.
Okay, thank you, Kyle. Just a little about the firm. It is the second largest law firm on Long Island. Among our practice areas are real estate, corporate, trust and estates, bankruptcy, commercial litigation, and I concentrate my practice on labor and employment law. So, you know, typically we represent employers in defending wage and hour lawsuits, discrimination claims, restrictive covenant litigation. We also get involved on a consulting basis. We're brought in to, you know, review employment practices. We're brought in on doing due diligence on M&A deals, and you know, part of my presentation today is, I'm going to start with a little bit of a case study and then segue into, you know, some of the issues we typically come across in M&A deals. So recently we were brought in to assist on performing the due diligence for a $700 million acquisition of a private Canadian-based company with extensive offices in the U.S. And, you know, we were, again, part of a team. I mean, there were 15 to 20 lawyers involved in doing the due diligence. So we reviewed, you know, pending litigation. We reviewed benefit issues. We reviewed employment contracts, employee handbooks, and we had to give advice on, you know, how these, and by the way, and also employment practices, and we had to give advice on whether these issues would have a material impact on the purchase price, and, you know, whether the purchase price should be adjusted based upon, you know, our findings. So again, you know, I work hand in hand with my corporate department here, which, you know, regularly handles M&A deals. So again, you know, you talk about the topic of employment law issues. So I'm just going to mention what we typically will be faced with and what we will address in the context of an M&A deal. So first of all, easily enough, we start with human resources policies. What is the pay practices? Does the employer pay overtime? We'll actually get involved to some degree on reviewing payroll practices to determine whether the employer correctly pays, you know, overtime, because, I mean, that is to not pay proper overtime in a larger company is literally a ticking time bomb, because at any given time, employees can go back 6 years and they can assert the claim as a class action, and we handle those class actions, and oftentimes, you know, it's an indefensible position. So in the context of an M&A deal, it's important to know whether the purchaser is going to be stepping in to a ticking time bomb situation. And by the way, you know, typically when we get involved in, you know, M&A deals, and anybody who's been involved is aware that, you know, purchasers can protect themselves with indemnification agreements and, you know, holdbacks and what have you. But there's actually case law in New York State, for example, that says indemnification agreements can't be used to in the context of a Fair Labor Standards Act, and by the way, a New York Labor Law Act claim. So, you know, the purchaser can't necessarily be comforted by the indemnification agreements in these deals. So it's important, again, for the purchaser to know what they're buying when they're, with respect to the payroll practices, when they're buying, another company. We'll review, as I said before, the employment agreements. We'll review the existing claims by employees, whether there's any pending litigation, whether there's been prior litigation, because that could reveal potential issues for a purchaser. Other potential claims we'll come across, for example, will get involved. A high rate of employee separations, for example, could be a sign of other issues within the organization. One of the big issues, which most attorneys and business owners will be aware of, is from a wage and hour standpoint, exempt versus non-exempt employees. A lot of companies believe that merely because they pay an employee on a salary basis that they're not entitled to overtime. And the mere fact that an employee is called a manager doesn't necessarily mean that that manager is exempt, because you have to do an analysis of whether that so-called manager is actually performing exempt duties. So we'll get involved in analyzing whether the seller has properly classified their employees as exempt or non-exempt. We'll also do the same analysis, by the way, with respect to independent contractors. Again, that's a hot issue, because if an employer has misclassified an employee as an independent contractor, that has the potential to create substantial liability for the seller, and as well as for the purchaser, potentially for the purchaser. We will review. I touched upon the overtime issue and the payroll practices issue, but aside from whether an employer properly pays wages, is also the issue of whether they properly track employees' time. Do they have a time clock? Do they have some system to track the time? Because if they don't, again, this could lead to other wage and hour claims by an employee or by a number of employees in the context of a class action for failure to pay all the wages for all time worked. Another issue we get involved in from an M&A standpoint is if the business that's being sold is a union employer, we'll get involved in reviewing the collective bargaining agreement. A lot of those agreements will contain successor and assigns clause. The employer, the purchaser, will have to be aware that they may be stepping into the shoes of the seller, and may and will have an obligation to negotiate with the union, but also may have an obligation to adopt the existing collective bargaining agreement with the union. So we'll get involved in advising on the union issues relating to M&A transactions. Also, with respect to an M&A transaction, if a seller is a union company that pays into a multi-employer pension plan, the sale of the assets could trigger withdrawal liability unless the sale is done correctly in accordance with an established federal statute. So what that means is that if the seller sells and doesn't comply with this statute, then that could trigger withdrawal liability. And withdrawal liability just generally is that if a multi-employer pension plan is underfunded, which means that based upon actuarial analysis over some period of time, the pension plan is going to have to pay out more than the assets that exist in the plan, then any employer that withdraws from that plan has to pay withdrawal liability, even though they may have paid every dime to which they were obligated to pay over the course of time. So again, the sale of assets could trigger a withdrawal liability, and that creates an issue in the context of an M&A sale, because actually the buyer as well could be potentially liable for the withdrawal liability. So that's an important issue, and we addressed that also in the $700 million transaction that we got involved in last month. We'll get involved in reviewing employee records and status. We'll do a mini audit to determine whether the employer properly is in compliance with all the records and requirements. The I-9s, for example, every employer has to have every employee fill out an I-9. We'll review those to see if there's any potential contingent liability for failure to properly complete and maintain the I-9 forms. There's oftentimes an issue in the context of a M&A deal as to whether there will be layoffs in conjunction with the sale, and if there are, that could trigger WARN Act obligations. The WARN Act is a law, and by the way, there's a federal WARN Act, and there could be a mini WARN Act. For example, New York State has a mini WARN Act which requires advance notice of a mass layoff, and if that advance notice is not given, then the employees would be entitled to severance pay for anywhere from 60 to 90 days, depending on whether the state or federal law applies. We'll review we'll get involved in executive comp issues to see if any of the M&A transaction will trigger any liability from that. Oftentimes, there are change of control provisions, in executive employment agreements that could come into play in the context of an M&A transaction. There are also, and there are other, so these are sort of the basic liabilities that everybody thinks about in the context of a sale of any business, but there are also hidden liabilities in the context of of employment law. So there is successor liability, for example, which means that if there is, whether there's pending litigation or not, if there's a discrimination claim, whether it's in the context of a pending lawsuit or hasn't yet been brought, the purchaser could have successor liability of that discrimination if they were aware of the discrimination claim.
And Doug, it doesn't
Yes.
matter if it's stock or asset, right? That successor liability transfers
Yes.
to the new owner.
It doesn't matter. Hidden liabilities, this is an interesting one, Kyle, and I don't know if you've ever come across this or if anybody's ever come across this, but if there's a sale of a business and this is on the unemployment insurance side, and the seller has a high experience rating, if the New York State Department of Labor will oftentimes treat the buyer as assuming the seller's high experience rating. We've had this issue several times, and it creates potential hidden liability for a purchaser, because the purchaser was operating as if they had a low experience rating, and all of a sudden they're stepping into the shoes of the seller with a way higher experience rating. We've actually tried to address this in the context of whether the tax indemnification law provision in the APA covered this scenario, but it's just something to consider also in M&A deals. So, this is a broad brush.
Doug, how can that be? What would your opinion be or suggestion be for a buyer that's walking into a potential scenario? Do you dig that deep and review their current unemployment rating, or no?
Yeah, we'll get involved. We'll get involved in that. We'll try to structure it in a way that the Department of Labor doesn't view the purchaser as having stepped into the shoes of the seller. But if they do, it could be addressed in some kind of indemnification language. But, it's an important issue to be aware of, and it's really, it really is rarely, addressed directly. If it comes up, as I said before, we try to address it in the context of a tax indemnification language, but it may or may not apply, and that could create litigation on the issue.
Of course.
So again, this is a high level, employment law issues in the context of mergers and acquisitions, and as I said, we get involved in these issues on a regular basis.
Thanks, Doug. Pretty good overview. You covered a lot of issues that come up as far as M&A related deals as it relates to employment law. I want to throw back out to the group. I don't want to pick anyone out, but I think I am going to pick some folks out here. I would like to have some feedback from Jackie and Winston, and anyone else has any comments or questions based on Doug's presentation.
So he's right on. So
Thanks, Jackie.
it's as simple as that.